Testing, testing. Welcome, one and all. Let us begin by approving the minutes from the prior meeting. I presume everybody's read them. Okay, a motion is to accept the minutes from the prior meeting. All those in favor signify by saying aye.
Aye.
Opposed, no. The ayes seem to have it. The ayes have it. Before we get into the administrative meeting, I'd like to announce some promotions in the commission. As you all know, we are in the midst of really staffing up to be able to serve the people of the state of Maryland, and in the course of that, we have an opportunity to promote some folks, and I'd like to recognize them. First, Evan Thomas. It's my pleasure to announce the promotion of Evan Thomas to Assistant Director of the Telecommunications, Gas, and Water Division. He joined the Commission in 2022 as a regulatory economist. And has consistently demonstrated strong analytic leadership in conducting complex economic and regulatory analyses. He has dual bachelor's degrees in economics and mathematics from UMBC, which is a really awesome school, by the way, for mathematics and sciences especially, and recently earned a master's degree in geography and environmental systems, also from UMBC. And Evan's expertise and commitment to the Commission's work make him well suited for his new leadership role. Okay. And also, I'd like to announce the promotion of Christine Ugwa. I hope I pronounced your name correctly. It's my pleasure to announce the promotion of Christine Ugwa to the Community Solar Regulatory Economist within the Energy Analysis and Planning Division. Christine is responsible for community solar applications review and processing, as well as assisting in the development of an online application portal to replace the current policies. Christine joined us in January of 22 as a solar renewable energy administrator, where she performed fantastically. And Ms. Ugwa holds a bachelor's degree in international relations and economics and a master's in international relations from Florida International University. This is an extremely important function for the state of Maryland. We're happy to announce your promotion. Alrighty then, let's get down to first the consent items. I'll read all four out, and if a commissioner wants to separate one of them, we'll entertain that. Item number one is Energo Power and Gas LLC. The request is to cancel its electricity and supplier license. I'm going to read the first three because the motion is the same for the first three. The second one is the same company, Energo Power and Gas, and they are requesting to cancel their natural gas supplier license. And finally, again, Energo, the request is to lift the surety bond requirement as a result. The motion for items 1, 2, and 3 would be to cancel the company's supplier licenses and to cease requiring the company to maintain a bond. You know what, we'll vote on these three first, and then we'll go to number 4. Any questions about this? Seeing none, all those in favor of granting the motion, all those in favor signify by saying aye.
Aye.
No, the ayes seem to have it. The ayes have it. The motions carry unanimously. Item number 4, Luella Enterprises LLC. It's a request to withdraw its electricity supplier license, and the motion is to approve the cancellation request. Unless there is any thought about this, we'll proceed to a vote. All those in favor of granting the motion signify by saying aye.
Aye.
Opposed, no. The ayes seem to have it. The ayes have it. The motion is granted. Let's now go to item number 5, Shenandoah Cable Television. The request for reissuing operating authority. The motion is to note the company is authorized to operate as a provider of resold and facility-based local exchange and inter-exchange telecommunication services in Maryland. Staff.
Good morning, Mr. Chairman and Commissioners. Evan Thomas on behalf of staff. The item here concerns a request for reissued operating authority filed by Shenandoah Cable Television LLC following a previously noted intra-company merger In 2019, the Commission noted the merger of Shentel Communications LLC and Shenandoah Cable Television LLC, with Shenandoah as the surviving entity. The merger was completed in April 2020, and following the completion of the merger, the company requested reissuance of its operating authority in its legal name following the merger, and no action was taken at that time. And so in December 2025, the company filed the instant request, again seeking issuance of a letter order. And so we reviewed the filing, and we have not identified any changes to the scope or authority or to the company's operations. And so accordingly, we recommend that the Commission issue a letter order that states the Commission has reviewed the request of Shenandoah Cable Television LLC, and the Commission notes that Shenandoah Cable Television LLC is authorized to operate as a provider of resold and facilities-based local exchange and inter-exchange telecommunication services in Maryland. So with that, available for any questions.
Thank you. Questions? Seeing none, would someone like from the company, is someone from the company present? Apparently not. In that case, does anybody else wish to comment? All right, we'll proceed to a vote. Commissioner McLean.
Aye.
Commissioner Linton.
Aye.
Commissioner Suchman.
Aye.
Commissioner Hoover.
Aye.
Chairman votes aye. Motion carries unanimously. Item number 6. Columbia Gas of Maryland revised tariff pages for updating its banking balancing service rider. The motion is to accept the tariff revisions for filing with an effective date of March 31st of 2026. Staff.
Good morning, Chair Barve and Commissioners. Alden Manka on behalf of staff. On January 30th, 2026, Columbia Gas of Maryland, Inc. filed revised tariff pages to update its banking balancing service rate, which is a rate applicable to commercial and industrial customers who purchase their gas from a third-party supplier. This rider covers the costs Columbia incurs for providing banking and balancing services to these customers. Historically, this rate has been capped at $0.00956 per therm, a rate Columbia has been at or near since the 2022 to 2023 billing cycle. Due to a recent Columbia Gas Transmission, or TCO, rate case, the banking and balancing costs charged to Columbia have increased. This led to Columbia filing for an increase in the BBS rate cap to $0.02283 per therm, which was granted by the Commission at the September 24, 2025 administrative meeting. Notably, that filing only increased the cap and did not change the rate. In the instant filing, Columbia proposes to increase the BBS rate from $0.00956 per therm to $0.01302 per therm. This increase is mainly due to increased storage capacity costs and not from a significant decrease in gas consumption. Staff recommends the Commission accept the proposed tariff pages for filing with an effective date of March 31st, 2026. Thank you, and I am available for questions.
Questions? No questions. Thank you very much. And I presume you're from the company. Please tell us your name.
Yes, good morning, Mr. Chairman and Commissioners. Caitlin Schweitzer on behalf of Columbia Gas of Maryland, and I'm here for questions.
Questions? No questions. I presume no one else wants to talk about this, so we will proceed to a vote. Commissioner McLean.
Aye.
Commissioner Linton.
Aye.
Commissioner Suchman.
Aye.
Commissioner Hoover.
Aye.
Chairman votes aye. The motion carries unanimously. Item number 7. Delmarva Power and Light has revised tariff pages updating electric vehicle charging program rider. The motion is to accept the tariff revisions with an effective date of March 4th, 2026. Okay. Staff.
Good morning, Mr. Chair and Commissioners. Eric Delgado on behalf of Commission staff. I'll also be presenting item 8, PEPCO's filing as well. On January 30th, 2026, PEPCO and DPL filed proposed tariff revisions to update their electric vehicle charging program rider. The companies are requesting to extend the current suite of Phase 1 commercial electric vehicles incentives until June 30th, 2026. The companies have previously requested to extend their EV fleet programs in July of 2025. The request was to extend the programs until the earlier of either June 30th, 2026 or the launch of the proposed EV Phase 2 programs upon Commission approval. The Commission granted this extension by letter order on August 6, 2025. Since the Commission has approved, in part with modifications, the company's Phase 2 commercial EV program offerings on January 29, 2026, the companies are now requesting that the end date for the current suite of Phase 1 commercial EV programs offerings to continue until June 30, 2026, when the companies expect to sunset the programs. Staff has reviewed Pepco and DPL's revised tariff pages and does not take issue with the requested extension. Offerings through June 30th, 2026, since the Commission has found the end date acceptable in the company's previous extension request. Staff recommends that the Commission accept Pepco's and DPL's proposed tariff revisions for filing with an effective date of March 4th, 2026. Thank you, and I'm available for any questions.
Okay, he spoke with respect to Delmarva and Pepco, so any questions on either of those? Seeing none, thank you very much. And Taylor, hi. Welcome back.
Good morning, Chairman and Commissioners. Taylor Beckham here on behalf of Delmarva Power and Light Company, as well as Potomac Electric Power Company. We appreciate staff's review, and we have no additional comments and are here for questions. Thank you.
Any questions for the company? Seeing none, we'll proceed to a vote. Commissioner McLean.
Aye.
Commissioner Linton.
Aye.
Commissioner Suchman.
Aye.
Commissioner Hoover.
Aye.
Chair votes aye. The motion, I didn't say, the motion was for both items 7 and 8. I presume your votes stay the same if it's for both items. And the chairman votes aye, and both motions carry unanimously. Items number 9 and 10 are being, what officially should I say? Dropped, deleted, deferred?
They are being deferred.
They are being deferred. Okay. Items number 9 and 10 are being deferred. We'll proceed to item number 11. Staff.
Good morning, Mr. Chair and Commissioners. Drew McAuliffe on behalf of staff. On February 19th, 2026, Baltimore Gas and Electric Company, or BGE, filed its request to waive the December 31st, 2026 expiration date of the Rate Year 3 distribution electric and gas rates approved by the Commission in case number 9692. Order number 90948 in case 9692 established BGE's current multi-year rate plan structure with rates effective through December 31st, 2026. Under the current framework, BGE is required to file its next multi-year rate plan no later than March 7th, 2026, to permit review and implementation of new rates effective January 1st, 2027. The company supports this request by citing the cumulative impact of several factors, such as customer affordability, extreme weather, and resource constraints that it argues would make a standard filing schedule contrary to public interest. To implement this delay, the company has specifically requested, 1, an indefinite waiver of the December 31st, 2026 expiration date for rates established in case number 9692, allowing existing rates to serve as a bridge into 2027. 2, approval to use riders 25 and 8 to recover incremental revenue, the difference between existing and newly approved target BSA rates, back to January 1st, 2027 for decoupled classes, for decoupled rate classes, ensuring the company is made whole for the gap period. And 3, the approval to create a regulatory asset or liability to capture revenue variances for non-decoupled rate classes, with the recovery period and carrying costs to be addressed in the next rate case. In exchange for this relief, BGE has agreed to extend the stay-out period, guaranteeing that any new rate increase resulting from the delayed application would not take effect prior to April 1st, 2027. Staff does not support BGE's request to extend the expiration date of Rate Year 3 distribution rates in case number 9692, subject to the proposed revenue recovery mechanisms the company has proposed. Staff's concerns are grounded in statutory authority, established rate-making principles, and customer impact considerations. Staff concerns are 1, there is a statutory prohibition on revenue reconciliations. 2, this proposal constitutes retroactive rate-making and violates the filed rate doctrine. 3, BGE is not entitled to these revenues and has not foregone any revenue. 4, BGE asserts that delaying implementation of these new Base rates promotes affordability. However, the proposal does not eliminate or reduce rate increases. It simply defers them. 5, the proposal risks introducing strained upward pressure on rates through the use of the BSA for several years. 6, non-BSA classes would accrue carrying costs through the proposed regulatory asset. And 7, delaying the filing would correspondingly delay commission review of high priority matters, including ongoing capital investments and compliance-related documentation. If the commission determines that administrative considerations warrant a filing extension, staff recommends that such an extension be granted without approval of the retroactive revenue recovery mechanisms. This approach would preserve statutory protections and prospective rate-making principles while providing scheduling flexibility. Then quickly, if I can respond, BG filed responsive comments yesterday to staff and OPC. Just wanted to quickly respond to 2 comments BGE made. So first, BG stated that this was not a reconciliation that they are proposing. And BGE notes in their filing that there's no forecasted revenues. They use the term forecasted many times. And they state that they're not reopening any revenue requirement, therefore it does not meet the statutory language of PUA 4213. However, the language in 4213 does not use the term forecasted. It does not use the term open up. It simply says that that current law does not allow for the public service company to file for reconciliation of cost or revenue variances of the approved revenue component used by the commission to establish just and reasonable rates. So staff believes that this is, now the company may not call it a reconciliation, but the fact is that it is, because you would adjust revenues that they collected, for example, from January through March for the new rates that you approve later on, then you'd go back and adjust the revenues they collected in that previous period. So it's a reconciliation in all but name. Then second, BG says this does not constitute retroactive rate making. Staff would also disagree with that proposal simply by the fact that if they delayed their filing, the order for this case would not come out till at least sometime in 2027. And if we're going to reconcile rates from the early period of 2027, you would obviously be changing those rates for that previous period in 2027. BG is stating that this is prospective, but it simply wouldn't be by the time the order comes out. And with that, staff is available for questions.
Questions? Commissioner McLean.
Morning, sir. How do you respond to BGE's comparison of their proposal to what occurred in 9702?
Well, so for so that's the PEPCO deferral. I'll also say they didn't discuss the Delmarva deferral, which Delmarva also has received an MYP deferral where they have not requested recovering any quote-unquote foregone revenues. I would say for PEPCO that was a little different because they were stacked on top of BG essentially, and we're filing a case 4 months later, and that was an agreement between the parties. Whereas this is, hey, we're doing this for the good of everyone, but hey, we still want our revenue that we're what they're calling foregoing. So I would say it was just different circumstances. And again, Delmarva was granted 2 extensions without any prospect of retroactive recovery of revenues.
All right. Thank you, sir.
Questions? Linton, then Suchman, that order.
Sure. Thank you. Good morning. So, could you respond also to
I went back to
one of the comments that BG referenced?
so much easier.
And I'm just going to call it a tracker because it's had several different names across the filings. But could you respond to the argument that the company raised, suggesting that these rates under the tracker could be issued subject to refund, as well as the initial rates that were issued, I guess back when, was that 23, I think it was, and the first, the current rates that we have now.
I don't see where they discussed a refund. Apologies, Commissioner.
They made the argument that the rates that are issued could be subject to refund. So in other words, it's not. This is more like a bridge between 2 administrative cases as opposed to something that is retroactive. I'm sorry, hold on. Turn this
Sorry, I'm just reading that paragraph again. Oh, wait, so they're not referring to this case where there would be, the revenues would be subject to refund. They're discussing
Right, the next,
gas purchase cases, fuel cases.
all right, let me, wait.
So
let
they're
me-
not saying in this case customers would get a refund for revenues. They're using that as an example, as in those cases, the commission prospectively says there can be an adjustment to the revenues in the future. They're using it as essentially defense for their proposal. Because they're saying that doesn't violate retroactive rate making in the fact that those cases are adjusted, the revenues at a future time period. And as Mr. Spivak just said, those cases are authorized by statute to work in that manner.
All right, well, I'll follow up with the company on it then. Is the staff concerned at all that the commission could eventually issue an order that lowers rates in the next rate case? And as a result, if we don't have a tracker, customers could lose the difference in refunds?
Concerned? I wouldn't say we'd be concerned if the commission lowered rates. I guess, so are you saying if we didn't allow this sort of mechanism, customers would be
Right.
overcharged, is your question? Well, so staff's proposal is actually not to delay the filing. We're not advocating for BG's position. If the commission wishes to just delay it, that's obviously within the commission's right. But staff isn't, we're saying that they should file on time. So then we wouldn't need to be concerned with this tracker. So did we really consider that? I'm not sure, but I wouldn't say that would be a concern for staff.
Okay. Okay. All right, thank you.
Commissioner Suchman?
So I wanted to talk about the decoupling mechanism.
Sure.
And BGE is asking for a regulatory asset or reliability for the non-decoupled electric and gas rate classes. So I can understand not allowing for the asset means that they can't subsequently recover from those customers any sort of increases or decreases as a result of the rate case that's going to be filed. But I'd like to talk about the effect on the decoupled electric and gas rate classes, which they're not asking for a regulatory asset, and I'm concerned that that would mean that they would be able to recover from those because of decoupling. How do we? And so is that your understanding as well?
What, yes, but so for both they would be collecting immediately. So the regulatory asset they would discuss in the case for those non-decoupled classes, and obviously there would be discussions on when that would be rolled in. But I believe, and the company can speak for themselves, it's my understanding that would be rolled into that case. It wouldn't wait for the next rate case.
No,
So-
but what I'm trying to figure out is how can if we allow for them to delay
Yeah.
the filing, but we don't allow for any recovery for that period, how do we ensure that for the decoupled classes the utility still won't allow for? I mean, it seems
Sure.
it seems to me that would be an automatic, and I don't know how we would be able to prevent that.
Okay, yeah. So now I understand the question. So, so the BSA is based on targets that are established in the rate cases. So even if you didn't approve the trackers, Commissioner Linton is referring to it, they wouldn't be able to kind of go back through the BSA and collect anything because it would still be those target revenues are addressed in rate cases.
Okay, so it would be targeted to the rate case, and they wouldn't be able to, because they're not asking for a regulatory asset for the decoupled rate classes.
Correct, because it is just a simpler way to do it. They can just put what they're calling their kind of foregone revenue into the BSA balance and recover it over time, because as you're aware, there's a 10% cap on the BSA, so it can't increase substantially. But so yeah, they can collect it over time slowly through that is their proposal. It's just a cleaner way to do it.
Okay, but can we, in issuing an order now, tell them you're not going to be collecting, you're not going to be able to recover any additional costs for the delay of the rate case?
I believe so, yeah. So if you extend the year 3 rates, I mean, the BSA targets for those months will be the same as they've been. Yeah, and any BSA changes would be going forward.
Okay, would you recommend that we be clear on that when we issue the order?
Yes, yeah.
Okay, all right, thank you.
Okay, I have no questions unless I think we're done there. We'll next, OPC.
Good morning, Mr. Chairman, Commissioners. Jacob Auslander on behalf of the Maryland Office of People's Counsel. BG is asking the Commission for 2 things. First, to keep its current rate year 3 base rates in place beyond the normal end of the MRP schedule. And second, to approve a revenue recovery mechanism that would let BGE later collect the difference between today's rates and whatever new rates the Commission eventually approves, effective January 1st, 2027. OPC is fine with the first part, the stay out, but not the second. The recovery mechanism is a true-up. It's an unlawful reconciliation of a revenue variance that the Next Generation Act prohibits for MRPs. And in any event, it amounts to retroactive rate making in substance because it would charge customers later for a past period when different rates were in effect. OPC is also asking for a separate, straightforward guardrail. The Commission should not allow BGE to propose a third MRP until the lessons learned proceeding is complete. BGE mischaracterizes that as OPC trying to bar BGE from filing its next rate case, but that is not what we said. In the letter that BGE filed yesterday, they said OPC's proposal to indefinitely preclude BGE from filing its next rate case would be unlawful. But in our actual filed comments, we go through at length to say that because the pilot is a Commission-created construct, the Commission can lawfully restrict BGE from filing a new MRP proposal until after the lessons learned proceeding concludes. Such a restriction would not prohibit BGE from filing for new rates generally. The PUA allows utilities to file at any time for a change in rates. Notwithstanding a limitation on the filing of MRPs, if BGE believes it is necessary to change its rates before the lessons learned proceeding is complete, the company is not restricted from filing an historic test year case. We say that again in the conclusion. So I'm not sure what the basis for the company's characterization of our comments as an indefinitely precluding BGE from filing its next rate case. That's not what we said. Instead, under our proposal, BGE can file a standard historic test year rate case at any time if it believes it is under recovering. The point is simply that an MRP is a discretionary pilot construct, and it's not an entitlement. The Commission should finish setting the rules for any future MRPs before issuing a third one. If the Commission wants to grant BGE schedule flexibility, it can, but it should not pair that flexibility with a true-up mechanism that the Next Generation Act statute bars and that functions as retroactive rate making. OPC requests that the Commission grant the waiver, reject the regulatory asset or rider recovery, and keep the MRP pilot orderly by requiring lessons learned to finish before any new MRP filing. And with that, I'm available for questioning.
Questions? Okay, Suchman, then Linton.
Okay, so in terms of your recommendation about us directing BGE not to file an MYP, I'm just trying to, and I understand your points, but I wonder if you can reference us to where in the PUA we have authority to tell a utility not to. I mean, we've told the utility to file historic when they file MYPs, but I'm trying to figure out in the PUA where we have authority to tell a utility that they cannot file an MYP.
Well, the statute is permissive. It says the Commission may approve the use of a multi-year rate plan for distribution rates only if the plan and it lists the criteria. And the Commission had previously ruled that the pilot utility, BGE operating under the pilot MRP is required to file either a new traditional or an MRP rate case at least 210 days prior to the end of the pilot MRP. Now, if you read the Commission's direction in Order 89482, it was clear that the Commission intended for there to be a pilot process at the conclusion of which would be a determination as to whether it was in the public interest for MRPs to continue. So we do think that because it was discretionary for the Commission to act in the first place, the Commission has discretion to restrict further MRP filings until it has made a determination that the construct is in the public interest, and that in particular that it provides customer benefits.
You understand that that goes beyond what's before us in this proceeding.
I do understand that it goes beyond what's before us in this proceeding, except to the extent that if the utility is waiving the expiration of its second MRP rates, that it could do that in conjunction with a restriction on filing a new MRP until the lessons learned proceeding has concluded.
Okay, thank you.
Oh, thank you, Mr. Chairman. Good morning. Commissioner Suchman actually asked part of the question that I was going to ask. The remaining piece was just the question to you as to what rates you believe the company should continue to charge once, if we say to them, do not file another MRP until the lessons learned process has completed. Should we just keep everything as it is? And
that is what OPC is proposing, is that the rate year 3 rates for the BG's second MRP would continue indefinitely. Unless and until they file file for a new rate case. We're asking that the Commission impose a further restriction and say, you know what, until we issue an order in the lessons learned proceeding, that new filing should not be an MRP. It should be something else, and that something else should be a standard historic test year rate case.
Okay, all right, thank you. That's all I had.
I think we have no further questions. Let's hear from the company.
Good morning, Commissioners. Chairman Barve, Beverly Sukor on behalf of BGE. I also have John Frayne with me. He's the VP of Regulatory Policy and Strategy, and Nancy McCart, the Director of Regulatory Strategy and Revenue Policy. As usual, I write out notes of what I'm going to talk about, and then OPC and staff give their comments, and I have to kind of recalculate everything. Sounds like you do have copies of the filing that BGE made yesterday. I do have copies if anybody needs it. I'm not going to repeat everything we said in there, but Mr. Frayne and I do want to highlight some of the more, I'd say, important things that we feel we need to highlight. We rushed to get those in yesterday, and so we maybe didn't address everything as thoroughly we wanted to. I'll focus on more of the legal issues. Mr. Frayne will focus more on the non-legal issues. First of all, it was interesting. Staff, in their comments just said this is retroactive rate making, cited no authority for it. OPC cited 2 cases that go to the general proposition that, yes, retroactive rate making is not permissible, but, it's kind of surprising that OPC did not mention the, cases that would have come up in any Lexis or Westlaw search that would have expounded on that, okay, here are examples where people said this is, impermissible retroactive rate making, and the Commission said, or the court said, no, that's not what that means. OPC did not, talk about those as we did in our response. We were, one of the first ones had to do with fuel rate readjustment clauses, where you set a rate to recover the fuel that utilities were using in their electric plants, but because that changes, you go back and you do a true-up. The court said, nope, that's not retroactive rate making. Retroactive making is you set a rate and you change it when there is no other, prospective mechanism that you put in place. And so it was, a little disappointing that OPC didn't acknowledge that there are, those cases out there. But also, it's interesting, I'm not sure what staff was, saying in terms of decoupling, but decoupling is kind of a short-term version of what we're doing. Again, we're truing up revenues after the fact. it's not retroactive rate making, and nobody has ever claimed that it is. You know, it's kind of the same thing that you say, here's the revenues that, you know, the utility is going to collect. Here's their, you know, revenues that, you know, they did. We're going to true it up. You know, again, I've been here for over 25 years. For the most entirety of decoupling, I've never once heard anybody say, oh, you can't do decoupling because it's retroactive rate making. There were also other plethora of tracker type mechanisms where you are essentially adjusting the base rates through a tracker. Not all of them are pursuant to statute, as staff seems to suggest, that, oh, statutes gave permission. Commission implements trackers and different surcharge mechanisms all the time that are basically a way of adjusting the base rates outside of a rate case. But again, don't hear people saying that's retroactive rate making. I mean, there are definitely cases of retroactive rate making. If the commission set the actual base rates and then said, oh, no, you know, there was something that was included in that, now we're going to change it, we're going to, you know, not give you recovery, that's different. Kind of similar if the utilities came in and said, oh, we want to get recovery of something that was otherwise included in base rates, we now want to get it. But if you set up some kind of mechanism like the commission does regularly, again, our tariffs are all full of surcharges and different mechanisms, that's permissible, and the courts have said that clearly, that that's permissible. Second point I want to raise is, you know, Pepco's 9702 case. You know, I think somebody mentioned that, oh, BGE didn't acknowledge the DPL case. Well, yeah, we didn't acknowledge the DPL case because it's really not, you know, okay, oh, DPL didn't seek to get a revenue adjustment. That's, okay, they didn't. But to me, the bigger point is, you know, Pepco, you know, when asked to delay the case by staff, you know, the condition for the Pepco company was to say, hey, we'll do it, but we're going to require, you know, we want some kind of revenue adjustment. Again, it's a very different mechanism how they went about doing it, but it's the same result. For 3 months, the 3 months of the delay, Pepco got to recover the additional revenues that it kind of lost out by the delay. You know, staff seems to justify why it's different because, well, the circumstances were different. Yeah, the circumstances are different. In this case, we're asking for the delay. That case, they asked for the delay. But you can't say those circumstances make it retroactive rate making. It's the same thing. So, you know, from a principle, rate making principle, if what BGE did is retroactive, proposing is retroactive rate making, then what Pepco did was also retroactive rate making. Again, different circumstances, acknowledge that, and that, you know, if that factors into your decision, that's a different issue. But you can't say that it's because who asked for the delay does or doesn't make it retroactive rate making. Again, there was a settlement in that case that both staff and OPC signed on to. Again, OPC mentions the DPL case as an example of, oh, a delay without any revenue mechanism. OPC doesn't mention that they signed on to a settlement with Pepco that agreed to this revenue mechanism. You know, I went back and looked at the settlement. I don't see anything in there where any party reserved the right to say that, oh, we maybe think this is retroactive rate making, and so we don't want to, you know, have it serve as any kind of precedent going forward. That's not in there. Parties agree to a mechanism that, again, different kind of how you get there, but this end result is the same. Pepco got revenues. Final thing I want to talk about is OPC brought up about, you know, the delay and whether or not then BGE could file another MYP before lessons learned. I think OPC is forgetting that the NGEA permits the utility to file the rate case, and the commission shall accept it, or it authorizes the commission to approve the use of an MYP so long as certain requirements are made. You know, OPC talks about, oh, the pilot utility and different commission orders. That was all before the NGEA was enacted. Now the statute's what governs, and you know the statute doesn't say we have to wait until a lessons learned. Now, certainly BGE wants to get a lessons learned. We want to make sure that whatever, you know, is the construct for MYPs going forward, you know, is, you know, workable. We want to improve this. We want to understand, how best to do this going forward. But, under the statute right now, we can file one. There is no, oh, you can't file one until there's, lessons learned. So, again, I think it's a little disingenuous to say that, oh, well, we're being precluded. Well, we are. I'm sorry, we're not being precluded, because we are. I can either let you ask me questions now, or I can hand the mic to Mr. Frayne to kind of talk about why or why.
Let's listen to Mr. Frayne, and then we'll entertain questions for both of you. Thank you.
Good morning, Chair Barve and Commissioners. John Frayne for BGE. First, thank you for considering this item on an expedited basis. We know that asking for this to be put on an administrative hearing here just a few days before the deadline for us to file an MYP was asking for you to expedite this. So we do appreciate that. Thank you. Second of all, I'd just like to level set a bit on what it is that BGE is proposing here. We are not proposing a reconciliation. We are not asking for a mechanism that compares what our revenues would be in this extended stay out period to what our actual costs are in 2027 and reconcile to that difference. That is the definition of a reconciliation in the statute, and that is not what we're asking for here or requesting. What we are requesting is that there be a deferral mechanism. If we were to be approved for this extension of the MYP stay out, there would be a deferral mechanism. That deferral would go both ways, meaning if the commission's revenue requirement that would ultimately be approved in our next base rate case for that period of time was less than the revenues that we actually charged customers during that time period, then that difference would be put into the decoupling mechanism and would be given back to customers over the period of time that it would take, given the 10% cap that Mr. McAuliffe mentioned is there with the BSA mechanisms. So that is how this is being proposed by BG. It is not a reconciliation. There are not any additional revenues that we are asking for here. It is simply to say, hey, for this decision to stay out from filing this rate case for a period of time, we would then, be allowed to take whatever that revenue requirement is that the commission might authorize in the next rate case and, defer that difference, whichever way it goes. Secondly, or maybe thirdly at this point, I would say, we are not proposing here that BGE be made whole in any, sense of that term. So the way that we proposed it, we are not asking for carrying costs on that decoupling deferral. So, if the commission were to approve a revenue requirement that did result in an increase in revenues, we would forego all of those carrying costs, and essentially it could be, for a fairly long period of time, because that decoupling mechanism does have that 10% cap that would ensure that whatever that deferral is would be, moderated in terms of how it would actually affect customer bills. But again, both ways. What I will say is that, after listening to staff's comments on the idea of the carrying costs for the regulatory asset, we're absolutely willing to forgo carrying costs on that regulatory asset as well. And we would even be willing to grant carrying costs for customers if there was a refund. So we will provide carrying costs to customers. It will be a one-sided mechanism in that sense for the carrying costs, and we do believe that that would be in the best interest of customers. I do want to also just mention a few other things. One, the way that the BSA decoupling mechanism works, and this is going to get a little bit technical, so my apologies up front. The way that that works is it looks at the shaping of the annual revenue requirement that the commission grants, and it shapes the annual revenue requirement into monthly revenue targets per customer. That shaping of those monthly revenues can change over time. It's driven largely by the billing determinants and how much usage there is in certain months of the year. So even if the commission were to provide approve a base rate increase in our next base rate case, it still could end up that, for this period of time where BGE is would agree to the stay out, that there would be a refund owed to customers, even if for the entirety of the year there might be an increase in revenue requirement that the commission is proposing. I'm not saying that's what would happen, but I am saying that's a possibility. So, this really is, I do believe, in the best interest of customers for the commission to approve. Sorry, I'm just looking at my notes to make sure that I cover everything. So, at the end of the day, too, I do want to emphasize that we do care about customer affordability, and we are considering it. It's why we, our preferred option right now is for the commission to actually approve what we're requesting here. We are doing this because we are concerned about what customers are seeing on their bills right now, but BGE also has the obligation to, maintain and operate the systems, the electric and gas systems, safely and reliably. And we need to make sure that we have the resources to be able to do that. And so we are looking to balance those two responsibilities and obligations that we have, and we believe that this proposal does that.
Thank you. We'll entertain questions in the following order: Commissioners Suchman, Linton, McLean, Hoover, and then the chair.
So if Commissioner Richard were here right now, he would actually have on his screen the great news that Exelon shared with Wall Street that you as a company did very well over the last year. So, those are not my questions, but I can just tell you that at a time when ratepayers are looking at very high costs, when you use language that suggests that we have an obligation to provide you with certain monies so that you can continue to maintain a reliable service, it kind of flies in the face of the great news that we all heard over the last couple of months about how well Exelon has done for its shareholders. But that's actually not my question. So I just want to tell you that it's just, that has, we're focused here on this proceeding, and it just feels a little disingenuous. But that's actually not my question. So I want to go to your initial filing on February 19th, and in the second paragraph, you spoke about factors that were driving this request, and so you talk about the extreme weather impacting customer bills and affordability concerns about utility bills due to electricity prices. And so I guess I'm a little confused because it seems that you're asking for us to ensure that you recover if you're experiencing increases in costs during this period the stay out period, that you're still going to ask for their recovery. You're just not going to ask for it now. You're going to ask for it later. So ratepayers are still going to pay for it. And maybe I'm just not understanding. So maybe you can explain to me how you're going to deal with the affordability issue in your request for stay out.
Well, yeah, thank you, Commissioner Suchman. So, one, I just want to make clear again that we are not asking for recovery of any incremental costs that we might incur in 2027.
Okay, you're not asking for it now. But
and we would not be asking.
And you will never, so for this 3-month period, let's say sort of 3-month stay out period, you will, so when you're setting up this regulatory asset, that's for what purpose? Because it sounds like you're not asking for any cost recovery.
So what we're saying, what we're asking for here is that whatever let's say that the commission, in our next rate case, let's say the commission approves this proposal and BGE stays out from filing our next multi-year plan until, let's call it July 1st. And that means that we would receive an order from the commission, and I'm not doing the math right, but it'll be sometime in April of 2027. Let's say at that point, when the commission issues its order, that the commission approves an increase of $100 for 2027. Let's say that, of that $100, that, $25 of it was, apportioned to the period of 2027 where rates had stayed at the 2026 levels. That $25 is what would be deferred into the BSA, into the revenue decoupling mechanism at that point in time. But let's say you look at what BGE's actual costs were during that same period in 2027 before the commission issues its order. Those costs might have been $30. We're not going to ever ask for, the difference between the $25 and the $30. Our actual costs in 2027 are not going to factor into what we're requesting here. What will factor into what we're requesting here is what the commission ultimately approves in its base rate, in its order in that next multi-year plan. And that will be based on...
How would we know about that $25, though? I mean, we would know about it because you'd be asking for it.
We would be requesting new rates, yes, for 2027.
Right, and that $25 in your example was for that period that you stayed out. And the only way that we would know about the $25 is because you told us about it, because you had asked for it.
Because you had, the only way that the $25 will ever come to be is because the commission authorizes it in that order.
But how would we know about it if you, Mr. Frayne, I feel like I'm not really clear, but I feel like you're making it so that it's not clear to me. It sounds to me like you are asking for us to allow you to get cost recovery in the next rate case for this 3-month period that you're staying out. And what you're saying is it'll happen only if we allow it, but we won't allow it on our own. We'll allow it if you ask for it and we authorize it. Unless I'm missing something,
Right.
I'm starting to get a little frustrated because I feel like you're not being clear with me. So maybe you could try to be clearer with me.
Sure. Yeah, my apologies. I'm not trying to not be clear.
No, I understand, but this is really important because I don't want us to be in a situation where we're then going to be looking at another rate case where you're going to be asking for cost recovery, and we didn't intend for you to get cost recovery for that 3-month period.
So just to be clear, the filing that we will make at some point, if the deferral is allowed, will be no different than I say no different, but will be largely the same as if we filed it tomorrow or Friday. We are not using actual costs for the time period of the delay. We will stick with what we have currently gotten approved in our LRP by our senior leadership. So we are stuck with whatever was in there now, good or bad, and again, we're going both ways. So it's not like for the however long we're delayed, we will say, oh, well, we forecasted that our costs were going to be 100, but they turned out to be 200, so now we're going to try and get the 200 instead of the 100. No, if, it turns out that it's 100, we are stuck with the 100. Nothing is going to be different except that at the end of the day, when the commission approves an order saying we are giving you a revenue requirement increase in 2027 based on your forecasted costs and everything for 2027, and again, it's a little more complicated because of the shaping, it's not like the $100, say, would be applied equally over each month. But if, say just for simplicity, if I'll do $120, evenly that it's $10 an increase each month.
Right, but okay, maybe this is where you're talking about forecasted, but we're also asking you to put historic in. And if you follow the path of your sister utility, then you're going to have this blended thing. And in whatever you're filing, is there going to be any conversation about this 3-month period of stay out?
Yes, but again, well, first of all, I may not agree with you about requiring us to do both a historical and a projected rate case. That was a PEPCO specific thing, we have not been ordered that in any. We do present historical information, but BGE was not directed like PEPCO was to file 2 different versions of its case. Just to be clear.
But is there?
But it's strictly just a matter of whatever revenue requirement gets, and I'm again a little confused because I'm not sure what the historical, if we file an MYP, that's what we're proposing. We are not proposing an alternate of.
Okay, but for the 3 months stay out, there's a possibility in the next rate case that you're going to be asking for some additional revenue. No, not at all.
No, we will, again, the revenue we will ask for, and again, there may be changes because of, say, commission orders. If the commission, I know there are some outstanding orders. Actually, I can't remember now what they are. The Drive Act, for example. Say, between now and the time we file, the commission issues an order on the Drive Act, and we know that we're going to have to incur additional costs because of the Drive Act. We're going to factor that in. Right now, we have a placeholder for, hoping that we'll get an order before the decision would have to be rendered. Otherwise, no, we are not. Again, we are going to go with the budget that is in place. The budget's not changing.
So you're going to hold everything in place from now until you file your rate case, and there will be no look back.
Nope.
No, I'm sorry, that's just not correct. They're getting, there's a lot of confusion here. They're still going to get that $25 that Mr. Frayne was discussing. So they are made whole for 2027. They're saying they're not going to adjust for new costs and variances, which is now illegal under law. So
all right.
They will be made whole for that year.
All right.
No, we won't. Not from a record.
Okay, hold on for one moment.
Yeah,
If one of the commissioners wants to ask staff a question, I'll allow that.
Right.
But in the meantime, we're going to be asking questions of the company in the order in which I announced. So
Okay.
the Suchman still has.
Right, and you won't be, okay, so you're telling me you're not going to look back to that 3-month period, nor would you look back 3 months before that.
Right.
So at no point during this MYP year 3 period would you be doing any look back when you do your next filing, whenever that is.
No.
And because it could be next year, or maybe you decide you're going to stay out for 2 years. You're never going to look back, and you'll just keep that rate in place until the time that you come to us for a rate increase.
Yeah, I guess, in terms of whether or not we would stay out for 2 years, I can tell you right now, there's no possibility that we could
I understand,
stay
Mr.
out that
Fan. I'm still trying to understand, and I'm not trying to be difficult. I'm actually really trying to understand
Sure.
how this is working, because we're going to have to issue an order. So we just need to be clear about what's going on. And I still don't have clarity because both staff's not ready to talk yet, but OPC have both made the same argument that you are gonna, when you finally do file your rate case, you're gonna be looking back
Yeah,
to that
and
3-month
when
period,
we
and you're
file-
saying you're not.
Right. So when we file the multi-year plan, if the commission did not, approve this deferral right now, we've been working hard, and we have a filing that we're getting ready to file. So that filing right now includes, as Ms. Sikora was saying, our current 5-year forecast, all of the costs and revenues from that for calendar year 2027 forward. If the commission does approve this this deferral and the revenue mechanism that we're proposing here, then let's say that we didn't file and we filed July 1st. That July 1st filing will still be based on the same 2027 forecast that we were going to
Okay,
be
well,
filing today.
I guess, so you won't have a problem if we issue an order that sort of follows the reasoning of staff and OPC, that you cannot look back to the 3-month period. I mean, maybe we just don't have an issue. I mean, maybe we're all on the same page. If we'll give you the deferral for the 3-month period, and for this 3-month period, you won't ever ask us for any kind of cost recovery. I guess it doesn't really make sense then that we would be setting up a regulatory asset, because you won't need the regulatory asset.
Well, I think this is where the confusion maybe is, because when we say we're not looking back, we're saying we are not looking back at the actual costs for that 3-month period. Let's say it was a 3-month stay out. What will happen under our proposal is that whatever the revenue requirement is that the commission might authorize and approve, let's say it was April 1st of 2027, that revenue requirement is going to be different than the revenue requirement that was underlying the January, February, and March 2027 revenues. What we will do under this proposal is defer whatever that difference is between the revenues that the commission authorizes at that point in time for January, February, and March of 2027, and what was actually charged to customers. If those revenues are less, we will be giving a refund to customers, and after my proposal here, that refund would include carrying costs for customers. If those revenues are, that revenue requirement the commission approves at that point in April 1st was greater than what had been, charged in January, February, and March of 2027, then we will defer that difference into the decoupling mechanism without any carrying costs, and that amount would then essentially bleed into customer bills through the decoupling mechanism ratably over time, subject to that, 10% cap.
I just want to add too that again, we pointed out the PEPCO mechanism that got approved in 9702. Again, I think some of the math is different, but the exact same result happened there that is happening here. PEPCO didn't refile with actuals. It got delayed. They used the same underlying data to support their revenue requirement request. It didn't change. And that's the same thing we'd be doing. The revenue requirement request that we have now based on our 5-year plan is what would get used. We're not saying that we would, if we estimated costs in, say we stay out for, 3 months, we estimated our cost to be 100, and, that's what we're going to seek revenue, a rate increase based on that, not on what the actual results are. But, we are seeking the revenue that, would be foregone. Now, again, the revenue is recovering costs, but it's the costs that were in our 5-year plan that will be the basis for
Okay,
the MYP.
well, let me just ask you this. If we were in a situation where we didn't have to worry about this 3-month period, And let's say that the rates, the MYP rate would stay in effect until July 1st. So you wouldn't need a 3-month delay. And then you'd file your rate case. In that situation, would you be looking back?
I think in that situation where there would be nothing approved, and if for some reason BGE chose not to file a rate case until you're saying July 1st of this year.
Let's say we didn't have this 3-month. We didn't have everything sort of moved forward, and so the expiration of the multi-year rate would have been July, not March. In that situation, would you be looking back three months if you filed on July 1st?
I think it would depend because, if we moved it forward to July 1st, it would depend on what we used for the underlying basis. If we used still a January through December, time period, no. But I would think if we were going to be delayed, we would be using a commensurate, time period. If we're looking at July, we're going to be basing it on a time period, so we would be kind of catching up. But I'm getting frustrated again because we're all concerned about this as if BGE is proposing something novel and different and perhaps nefarious, maybe. But this is exactly what PEPCO got approved by everyone. The commission, staff, OPC agreed with it, and so it seems like people's, staff's main issue is, well, that's because they proposed it. They asked.
Well, they didn't ask for the cost recovery piece, and that's.
We're not asking. No, the ultimate result is exactly the same. PEPCO did the cost recovery that you're worried we're getting is the same thing that PEPCO would have gotten in that case because they did the same thing. All that happened in that case ultimately is that the revenues that the commission awarded to PEPCO for those months that they agreed to stay out, they got to recover. That's exactly what we're asking for. There is no, again, how the steps to get there are different.
Well,
but the ultimate result is it's just a difference between the revenue that we are collecting during this time period based on our old rates and then the revenue that you would authorize us in a rate case that would cover that time period. Again,
well, but what we authorize based on what you're asking. But I think that I would let my fellow commissioners ask questions, and I'm looking forward to hearing from staff and OPC. Thank you.
Commissioner Litton.
Thank you, Mr. Chairman. Good morning. For BG. So it's been a bit since I've talked about some of these issues. I was sitting in a different location back then, but if you could just refresh my memory, there's some preliminary steps that the company is supposed to take prior to filing an MYP. Some transparency-related communications with People's Counsel and staff and other parties. Have those things already happened in preparation for the filing that's supposed to have happened on March 7th? Or within the next couple of days?
Yes, Commissioner. If you're referring to like pre-filing meetings that we typically have with staff, OPC, those have not taken place yet. They typically, what would be discussed in those pre-filing meetings is high level, information about what we're planning to file, maybe some details about anything new that we were including in the filing. Because of those meetings we had planned to have over the last couple weeks, but because of this, proposal that we filed, we've held off on having those meetings to date.
Okay.
And I'll just add, that pre-filing kind of notification was something that was, part of the lessons learned that has yet to be ruled on. And I'll say that that's the only thing from the lessons learned. BGE agreed and PEPCO or PHI agreed to a whole list of things. That is the only thing that we are not incorporating into our filing, or that we would be incorporating. Again, because of the, things that, Mr. Frayne said, why we hadn't got to that point yet. But, it's not, there is nothing in any current commission regulation or requirement that says this stuff has to happen. Again, we propose, or we agreed to do a lot of things in the lessons learned, and we are doing a lot of that. Well, we are doing all of it except that particular one because of, the timing of everything and trying to figure out what to do going forward.
Okay, well, I'm trying to remember a lot of this, but I believe that that was part of the original purpose of the pilot, which is to make sure there was that transparency between what the companies were going to propose and what the industry, I'll just say, and the agencies understood you were going to file. So it wasn't just supposed to be that they see it for the first time on the day you file it.
Right, and I understand, and I would even go further than that and say that one of the benefits of the multi-year plan is that it's not just a pre-filing meeting. Pre-filing meetings happen with, I think, most, if not all, utility rate cases, whether they're multi-year plans or not. With the multi-year plan, the transparency really comes in what is actually reviewed and provided during the course of the proceeding. And we have agreed to, it's actually something we've done a lot of in the 2 multi-year plans that BG has already filed, and we'd be doing more of it in this 3rd multi-year plan that we plan to file, meetings with staff, with OPC, with other parties to discuss what is included in BG's filing. Those happen throughout the proceeding. I just want to make clear that the multi-year plan is a much more involved process than kind of traditional rate cases, which all have usually typically included these pre-filing meetings.
I just wanted to add, we have met with staff and OPC about various aspects of what was going to be in our filing going forward. I mean, there were certain aspects that the commission in the last order, said we needed to work with the parties on it, and we have been. So, was there a specific meeting about kind of the big picture? No, but it's not as if we haven't been talking. And I will say we did reach out to staff and OPC about this, our proposal before it was made. So our filing was not, their first, for staff, that was not the first, and afterwards we have reached out, so.
Okay, so thank you for that. I guess staff and People's Counsel can cooperate or respond if they needed to later, not right now. But I guess what I'm trying to get to is we know of course that this particular filing would have been due, I guess, this week. We have the staff and to a certain extent the People's Counsel opposing the waiver request. And I was asking about the preliminary meetings and other things that were supposed to happen prior to the filing, because I'm trying to see if this voluntary request is necessitated by the more basic fact that the company's not ready to file, or is it that there's some other issues that suggest that if the commission said we agree with the staff, no waiver, so we expect a filing on Friday, or is the company still saying we will delay moving forward with or without a tracker type of system or mechanism attached to it?
Yeah, I think what I can say is that we are ready to file. We've been working hard. If we'd have to go back, and I can't tell you exactly when, but we will be filing. We will be filing, and if the commission doesn't, approve the proposal here, or then what we will need to do is actually, I'm sure we will reach out to staff and OPC to have conversations with them, whether we file on Friday and those conversations happen on Monday, or whether we file on Friday and those conversations happen on Thursday, is going to depend on, schedules. We fully intend to, be transparent in what we file, but we are ready to file.
Okay, so the question of whether or not the company will file or not file isn't necessarily reliant on whether or not the company gets a tracker.
if the commission doesn't approve what BG has proposed here, we're ready to file and we are going to file.
So it's waiver plus tracker. I'm sorry. I think it was your turn. Or was it
Yeah.
my turn?
Sorry, if you could repeat the question. Yeah.
If the commission does not grant, if the commission grants the waiver but not the tracker,
Gotcha.
will the company still decide to wait, or will you file?
Yeah. So what I can say is we're ready to file, and we are going to be filing. Whether we would file on Friday or whether we would file on Monday or some other date, I'd have to go back and talk. But we're ready to file, and we will be filing if the commission isn't willing to approve the extension of the MYP stay out period and the deferral mechanism as we've talked about here. Yeah.
So it's basically the proposal that the company has presented through its filings. If it's not the waiver plus what we've been calling today the tracker mechanism, or
Yeah.
at some point within a very short period of time.
Yeah.
I won't say Friday or Monday, but just.
And I can't give you the exact date we're
Right.
going to file, but
Right.
we are ready to file, and we're going to have to file at some point. Whether it's I can't give you the exact date, right?
Right, of
Because
course.
we'll have to go back and talk about that internally. But yeah.
Okay. So I have one other question. It's partially inspired by the People's Council's comments. And I wasn't on the bench, at least, for the lesson learned process that happened. I'm familiar with what happened, but I wasn't here at the time. We're now looking at the potential for a third MYP filing that happens after the lessons learned process. So is there something about this third, and I know this is a little out of the realm of what we're in front of, what we're dealing with in front of us today, and I appreciate that, but since we're all here, is there something about this MYP that the commission could look at to say that there's a lesson learned in it that wasn't already addressed?
Yeah. So Commissioner Linton, what happened in that lessons learned process so far was, a series of filings, some briefs, updated briefs. This past fall, there was hearings, and as part of that whole proceeding, BGE actually took a lot of feedback from the commission, from staff, from OPC, and we actually, and I believe it's in our December 2024 briefs in the MYP lessons learned proceeding, case number 9645. We do have an attachment to that brief that lays out all of the improvements that everyone had agreed upon, at least in that proceeding. And had committed to actually including those, improvements to MYPs in our next MYP filing. And that is exactly what we've done in preparing for the filing that we're discussing here today, is we are including all of those improvements, as well as the, other requirements that, have now been codified in statute for multi-year plans in the Next Generation Energy Act.
Okay, that was going to be my next topic or question, but again, that's not necessarily what we're here on today, but it's related.
I think it's a fair question because it goes to the question of how prepared we are to file right now, and
right.
we're prepared.
Well, that's my point, is if we actually have a statute that impacts our pilot, which is a little unique structurally, but that's the scenario we're working with now. So is it fair to say that the company has properly briefed People's Council, staff, other parties under that same theory of transparency, with all of the changes that you just mentioned were incorporated into your soon to be, or maybe a little later, but soon to be filed MRP? Are they ready to? Are the other parties aware enough of what changes you've made in order to be able to respond to it?
Well, the changes that we're talking about here have been out there as commitments from, the Exelon utility since December 2024. So in that sense, yes. But, if you're asking, again, have you had a pre-filing meeting where you walked through, what you're planning to file right now and talked about, each one of those, improvements that had been committed to? No, but that's what, I think we would endeavor to do. If the commission didn't approve this, we would be looking to, kind of have those conversations either right before we filed or maybe right after, depending on the timing of what we ended up deciding.
I'll just add, a lot of the improvements that
Could you go a little closer to the
sorry.
microphone?
A lot of the improvements that we're making were things that OPC and staff proposed or requested. So it's not like it was stuff that BGE came up with necessarily on its own. This was us getting the feedback from them and agreeing to it. So
No, that's fair, and I appreciate that. I guess I was just making sure that if the staff said it'd be great if you did A, and then you decided to actually do A, and they weren't expecting that you were doing that right away, and so now there's some work or preparation they need to make to be ready for that. So that was my concern, and I guess it's, since they know what they propose, I guess they can respond to that.
I don't believe these, types of improvements that we're talking about here and been agreed to are probably going to require a lot of resources or time or effort on the, part of OPC or staff, but I don't want to speak for them. That's just my belief.
Okay, all right. Thank you. That's all I had. Thank you, Mr. Chairman.
I wanted to add, most of what we were proposing was to make it easier, to maybe make the filing, and so it wasn't stuff that necessarily would, I think, add to their workload. It was to make their, review and response, less difficult.
Thank you. Thank you, Mr. Chairman.
Commissioner McLean.
Thank you, sir. My colleagues have hit on a couple of the areas I wanted to hit on, but you reference affordability and customer impact as two of the main, or two of the reasons for your request. If that's the basis, or some of the basis, why not just take the DPL approach? Just let's hold these rates constant until we file and get another order.
Yeah, what I would say is, again, I want to go back to what our obligation as a utility is, right? We not only have to hold customer affordability in one hand, but in the other hand, and probably a little bit higher, we have to hold the obligation to operate and maintain the system safely and reliably, and that's what we're trying to do with this. Now, in the interest of customer affordability, we're looking to do this deferral because we, understand how challenging a time period this is after, a winter like we had last year and the winter that, we've had this year. It's a challenging time for customers and what they're seeing on their utility bills. And that's not just, from what they're seeing on their BGE distribution charges. It's the totality of their bill, right? But at the end of the day, it's also why we're saying we looked to be as creative as we, could, as creative as, maybe regulatory accountants can get, and use this, BSA decoupling mechanism, because it really is a mechanism that allows for, and makes sure that the way that this would, kind of be flowed onto customer bills, again, either way, would be in a measured, moderated way because of the cap, right? And it wouldn't be something that customers are going to, because of that see or feel. Today, that decoupling rate changes every single month. Sometimes it's a little bit of a charge, sometimes it's a little bit of a decrease in the rate, and that's exactly how this would work too.
Thank you, sir. Thank you, Mr. Chair.
Commissioner Hoover.
So you talked about this with Commissioner Linton, but just so I understand, your view is that this proposal is an all or nothing deal. So you're not, I'm thinking about staff's second part of their recommendation saying that we accept the deferral but deny the recovery mechanisms.
Yeah, we can't accept an indefinite deferral at this point. If the commission wanted to say, we'll and the reason that I'm saying we can't accept an indefinite deferral at this point is because we're going to file. We're going to need to file. Now, if the commission wanted to say that the current 2026 MYP approved base rates can stay in effect until BGE files and let there be a little more time, you could certainly do that, and that could allow for some of those conversations that Commissioner Linton was having or was asking about with staff and OPC and others. We wouldn't be against that, but we can't agree to an indefinite deferral at this point because we're ready to file and when we're going to need to file.
Okay, thank you.
Can I just add, we also can't, agree to not file an MYP until the commission issues a lessons learned order. I realize that OPC is making the decision that we can file a case anytime we want, but, to condition filing an MYP on getting the lessons learned order, again, would be, not that I don't think the commission isn't, working hard to get that order issued, but that would put us, again, at a disadvantage improperly because the statute does allow us to file an MYP.
Okay, thank you.
I don't have any questions. Any other second bites of the apple before? Apparently not. We're going to take this under advisement.
Excuse me, Mr. Chair.
What?
So I would appreciate actually hearing from staff
Sure.
and perhaps OPC, and then maybe we'll have some follow-up questions.
Go for it.
Thank you. Apologies for interjecting earlier. So yeah, I think there's just some confusion that I was just confused trying to alleviate. So when you're using the term look back, Commissioner Suchman, I think there's just a disagreement on what that term means. So just say BG defers 3 months and they have rates effective April 1st, 2027. Just say you approve a $100 million revenue requirement for 2027 and BG missed out, forgave $25 million those first 3 months. They will be collecting that through the BSA and that regulatory asset. So when you were saying you won't be looking back and getting anything, I think there was some confusion there. They will be getting those funds. But what they were saying is they won't update the 2027 numbers they provided for variances in costs, for example. So just say there was a big project that they thought it was going to cost $10 million, it actually cost $20 million. They were saying they weren't going to look back and adjust those figures, but they're still going to get that revenue requirement, or they're proposing to still get that revenue requirement for the early parts of 2027. So is that, and Mr. Franken, feel free to correct me if I'm wrong.
Okay, so just to be clear, if we were to issue an order that said that they could not recover those costs, that would be consistent with what staff is proposing.
Yes, and OPC, I believe.
Okay.
Yeah.
Thank you.
Yeah, and I'll just say, if they filed their case March 7th, as they're scheduled to, it would be illegal for them to actually adjust for those 2027 costs because reconciliations of costs and revenues are now illegal. So if they filed on time, they would never be able to adjust those 2027 costs and revenues because they're now illegal.
Well, and just to be clear, if we're extending this the current rates, it's in case 9692, which basically is their year 3 reconciliation. When they file for a new case, it's going to be a new case number. So it just seems to me that if you're asking for recovery, it's in the multi-year rate case year 3. That is an additional reconciliation, it seems to me. But I'm not making a determination of legal effect. I'll leave that to our general counsel's office.
Sure. No, I just wanted to clarify that according to PUA 4213, they can't reconcile anymore. So if they were to file that new case in the next week or so, they could not adjust those first 3 months of 2027 for actuals at any point. So.
Right, because it would still be in the MYP year 3 case.
Well, no. So
No, I'm just saying that we're sort of essentially just extending year 3 for another couple of months before the new case kicks in. That any adjustments to that year 3 would not be permissible under the new statute.
Yeah.
Okay, thank you.
But that was all I was trying to clarify earlier.
Very briefly, I just wanted to agree with Mr. Frayne that no discussions along the lines of what Commissioner Linden were referring to have taken place regarding the filing of of a third MRP. I also want to say that although I wasn't intimately involved, apparently we did not ask for or agree to any improvements to the MRP process in our briefs. We actually said that the reforms that the Exelon utilities and other stakeholders have proposed to Maryland's MRP construct cannot align it with the public interest. That was in our December 2024 brief, and in our updated brief filed in 2025, we again opposed proposals and said stakeholder discussions are needed before any reforms are agreed to. And then one other, minor point is that in regards to the PEPCO settlement, I mean, I think there were some differences. I think one is that to the extent that that the commission agrees with our argument that the recovery mechanism that BG is proposing is a unlawful reconciliation under 4-2213, that prohibition was not in the law when the PEPCO settlement was agreed to.
Okay.
Actually,
Go ahead.
so given what BG&E said about this being a sort of all or nothing deal, on behalf of your clients, you're not willing to accept this deferral idea as a benefit if it comes with these other cost recovery strings attached to it, correct?
That's correct. And then not to belabor the point, but because of the level of hardship, frankly, that BGE's previous MRPs have inflicted on residential ratepayers, we do not believe that it's in the public interest to even permit BG to move forward with a third MRP unless there are guardrails that the Commission has fully considered and determined to be in the public interest before they allow the utilities to routinely file multi-year rate plans. And make no mistake, that is what would happen if BG is allowed to file a third MRP.
Well, I think we're now wandering off the topic before us.
Appreciate your point, but I think you're right. So, okay.
Anyone else have any questions? All right, we will take this under advisement and act expeditiously before.
I'm sorry. Can I just make sure I was clear on one point, right? So, I don't think I'm trying to say that this is an all or nothing deal. I apologize if I came across as I was trying to put the commission into, between a rock and a hard place, so to speak, right? What I am trying to say, I'm not trying to say that, the commission can't extend the, existing MYP-based rates past January 1st, 2027. We would be okay with you doing that. I'm not trying to say we are ready to file, and I'm not trying to say we're gonna file on Friday or we're gonna file on Monday, but I am trying to say we need to file. We need to balance, safety and reliability with affordability. And so I am trying to say, that we can't just stay out indefinitely, and that we will be filing, if the commission doesn't give approval to the mechanism that we're asking for. It's just, I can't tell you it'll be Friday. I can't tell you it'll be Monday. It's going to be happening though here, and I just wanted to make that clear because I think I could have come across a little differently perhaps earlier. And the other thing I would just say is that, again, I apologize, Commissioner Suchman, if I was confusing earlier. The revenue requirement that the commission approves in the next rate case is going to be the revenue requirement the commission approves. We are not asking for anything different than that revenue requirement. All we're asking for is a mechanism that would take and compare that revenue requirement to what the existing revenue requirement is, and if it's higher or lower, that difference would flow back through the decoupling mechanism.
So and just to be clear, if we did not allow that, that would be something that you would object to. That would be among
that is, yes. If you do not, think that that's something that you want to accept or approve or agree to, then at the end of the day, we're going to have to file again. It wouldn't, be against you extending the, expiration date, so to speak, for the existing rates right now, but it does mean that we're not going to be staying out the length of time that we've proposed.
And then Mr. McAuliffe, is that based on my just my dialogue just now? That is also your understanding of what they're asking and what you're objecting to?
Correct, that they go back and adjust, yeah.
Yes. Okay. Thank you.
All right, and with that, we are adjourned and will act quickly.